How's the royal family? I pray that everyone is doing well. Well, my royal family, it's another one of them videos, my royal family. I'm going to keep bringing it. You know, I always deliver. Always the best for the royal family. And so I did not know that there was going to be a press conference today. And so before we get into that, so now you got your head hung low and you're feeling some kind of way. Oh yeah, this is a true, my royal family, a true nigga moment on the world stage, because this case is just not being seen in America. It's being seen around the world, how this country gets down and treat the chosen ones. And folks that look like you and I ain't necessarily you and I. So, like I had said, as we continue on, I have never, ever in my life, ever heard anything about a grand juror, because it's all done in secrecy. Didn't even know they had certain rights. And based on the last video that I put up, things moved very quickly. And it was like I said, in order to get that motion put in place, that paperwork was done Monday. It was stamped at 4:18 p.m. You know, the courts close at 5. So the players that's involved in this had to have a lot of power and momentum to even get this pulled off. But let's not lose sight. They look at him for what he really is, a true nigga. I've been saying this day one about him. And they're going to show him what kind of power they have when you try to pull off something that is blatant. It's blatant. Now, they have always done this to us, but some stuff is so blatant and so obvious that it ain't a good look. So anyhow, I have a full press conference here. And I know sometimes the sound is janky, so I do have the subtitles on there. So now we're even able to read what the reporters ask the attorneys. So we got 41 minutes and 14 seconds. Powerful, my royal family. So let's lean all up in it. Let's see here. May not be able to get it full screen. Let's see here. Let's see. Okay, let me see here. If I can't get it full screen, I can blow it up some. And I think I can bring it over a little bit. Let's see. Can I do it like that? It's off-centered. Wait a minute. Let me take this down. Because I've done this before, and usually they have a bar that you center it back. So it will not allow me to, in this particular situation, it will not allow me, let's see here. Let's bring it back to reality. It will not allow me to play on TV. Let's click and see what this is. I never clicked it. Let's see. Nope, that don't work like that. Okay. Let me do one more thing here. Try to see. Exit full screen. Let's see, F11. Let's see here. Okay, let me see how much more I can bring it up. Forgive me, my royal family. I cannot get this centered, but I'm going to blow it up as much as I can so you can read the subtitles without things looking, I don't think it's going to look distorted at all. Let's see how far we can take this. Okay, that's a lot better. Okay, I'm going to leave it where it's at, right there. And let's see if we can get the subtitles on this. Let's see here.
Yes, sir. Good morning, everybody. First and foremost, let me thank you all for being here. Thank you all for your continued service to the community at large, asking all the good questions, and trying to help everybody find the right answers. Today, I have my legal team here with me. My name, in case you don't know, is Kevin Glogauer. And as a group, we represent an anonymous grand juror in the Breonna Taylor case. To my left, this is John Britton. To my right, Eric Weber, Matthew Farah. This is an issue that is about accountability, it's about public trust, and it's about transparency. The grand juror that we represent felt compelled to take some sort of an action based upon the indictment that was rendered and the subsequent press conference and messages from the Attorney General's office about how everything played out. At this time, we filed a motion late yesterday to release any recordings, transcripts, reports, etc. of the grand jury. As you all well know, Judge Ann Bailey Smith, in the arraignment for Detective Hankerson, ordered exactly that through the discovery process, and that's something we can discuss. If you all ask the questions, I'll happily address it. But the other part of our motion also was to get a declaration of rights for our client, which would also apply to any other grand juror that was a part of this process. Specifically, we wanted to know from the court system if a grand juror would have the right to speak freely without fear of prosecution, persecution, condemnation, torment, etc., about their experience as a grand juror in this proceeding. Again, our client felt compelled to take action, but before our client can discuss these things freely, they needed to know the rights and duties as deemed by the court. This is not a situation or a case where anyone should be acting without an abundance of caution and exploring all of their options appropriately before they start speaking freely to the press. That includes all interested parties. The grand juror wisely sought some guidance and decided ultimately to file the motion. I cannot really speak to anything that's privileged, obviously, that was discussed, but we're awaiting the ruling. We are aware of the Attorney General's statement made late yesterday, which I will finish up my opening remarks stating I think it was a well-worded 2-paragraph public statement that says they will follow Ann Bailey Smith, Judge Ann Bailey Smith's court order. I'm not sure it really says much more than that. But since you all are helping everyone here in Louisville kind of understand what's been going on with this case, I will gladly answer any questions that I can, and I'll open it up for that to happen. Yes, sir, Mr. Wolfson.
What in particular was your client aggrieved by? Can you say what their concerns were?
The primary concern that our client has is, if you watched the press conference after the reading of the indictment, the Attorney General laid a lot of responsibility at the grand juror's feet. If you look at the statement that the Attorney General's office released yesterday, they attempted to walk that back. And I think the concerns, as we noted in our motion of the grand juror, probably got their attention. And hopefully that's going to help facilitate a little more transparency in how things occurred.
Does your client believe that the Attorney General lied during that press conference?
My client wants to make sure the truth gets out. My client wants to make sure that anything that happened in there becomes something of public knowledge to the extent it's legally allowed to.
Kevin said he's going to release the recordings. What will the recordings reveal about
Couple things with Ellen. He said he's going to release the recordings because he's now ordered to publicly file it as discovery in Detective Hankison's criminal action. So that's not exactly the same as just a blanket release, in my opinion. But it will have access to the public, the press, etc. So get it. What I would expect you will hear is only testimony that was provided, whether it had been through audio or video. I cannot tell you if it was a video recording or simply audio. Generally speaking, in the Commonwealth of Kentucky, and in Jefferson County specifically, the grand jury proceeding only records the opening statement of sorts of what it's about. A witness is then called and sworn. They give limited testimony, very short in general, and at that point they go off the record, stop the recording. Prosecuting body, whether it be the Commonwealth Attorney or an Attorney General, would make a recommendation at that point, or choose not to and tell the grand jurors they're not making a recommendation. And they deliberate privately, and then they return their decision. So to answer your question, the expectation is it's going to be something similar to that, but on a more lengthy scale than what we would typically see.
Can you tell us about more about this grand jury that identified? Filing cases, clearly, age, race, and how soon after the grand jury proceeding did he contact the legal team for clarification?
I can't give you any specifics about our client, because at this time they want to remain anonymous, or as anonymous as possible. We're aware that people are looking around and asking questions, and I appreciate the question, I just can't answer it. And I think the second part of your question again, how soon did they contact?
Same day, was it the next day?
It was Friday afternoon, so 2 days after the press conference and the indictment. And I think the only lag there was just trying to wrestle through what they had seen reported and then released at the press conference and figuring out where they go from there.
The New York Times.
Hold on, she was trying to ask something.
How unprecedented is this request, and when the grand juror reached out to you, what was their state of mind?
As far as how unprecedented is the request, I don't know. I can tell you in 15 years of practice, I've personally never seen it, but I only practice pretty much in Louisville, Kentucky. Whether or not something's happened anywhere else, I couldn't tell you. The research that we did prior to filing is so narrow in scope, but I did not really find anything similar where a grand juror was requesting some sort of declaration of their rights. The state of mind, I think, is what you asked me when the initial contact. I think the best way to state that in that conversation is more a curiosity of where they fit in and what abilities do they have to participate in the conversation on a grander scale. Because grand jurors, what we hope is that they take their service very, very seriously, and that they look at everything that's brought to them and make their best decision collectively with the other grand jurors. I will tell you, it's my opinion, our client did exactly that. But after everything got released, certainly not everything, but you know what I'm saying. They wanted to know what ability do they have to participate in that conversation to help kind of illuminate the entire process.
They felt the entire process wasn't correctly presented by Attorney General?
I think they were aware, and I think you would probably agree if I asked you that there were certain questions that were left unanswered.
When do you expect the judge to rule on whether your client is guilty?
I don't know. A declaration of rights is an interesting action, especially when it's in concert with a grand jury proceeding. Generally, it happens faster than a civil lawsuit. So, best guess maybe in a couple of weeks, but it depends on what the actual responses are. If you all looked at the pleading, we noticed every counsel we could find for an interested party. They would all have a right to respond, in my opinion, if they so chose, and that could affect the timeline.
Is there one thing specific that was said, or rather unsaid, that the grand juror wants revealed? Can you tell us that?
I can't tell you that because that's a privileged conversation that was held with our client, but I can tell you that, as we stated in our opening, that it's the accountability and the sense of public trust to make sure that everything that can get out there does, and there was some concern that maybe it wasn't. But again, as I was saying over here, it was trying to figure out what rights do you have and what abilities do you have to help that process. Yes, I know you've been trying to ask. Well, I don't know, because I haven't seen all of anybody's investigation. But what I can tell you is this: when a grand jury in the Commonwealth of Kentucky indicts an individual, and their case matriculates to the circuit court system, they have an absolute right to discovery, which is to see anything and everything that is against them. Detective Hankinson has that right. His lawyer will see every bit of whatever the Attorney General presented and whatever they have in their file. So as far as it compromising an additional investigation from federal authorities, I don't know. If the federal authorities are looking into something that wouldn't be encompassed in that discovery, I don't really understand how it would impact it, but without full knowledge, I couldn't tell you if I think it would. Yes, ma'am.
Kevin said last week that you walked him through all of those possible charges. So that's based on the conversation with the client, or can you just focus on one?
Well, again, I can't really tell you what I discussed with my client, because my client has an absolute privilege in their discussions with us. Hold on, I'm sorry. Anyway, the walking them through the 6 different homicide charges, I don't know if that happened. I can't tell you if that happened. What I can tell you is with the release that was put out last night by the Attorney General's office, they're now acknowledging that they only recommended the wanton endangerment charges towards Detective Hankinson. What they're not telling you in that release, which is still a question, is what was actually presented to them, if anything. What were those charges? Who were the defendants or potential defendants? And then what was the recommendation, if any? Yes, sir, I'm sorry.
You hit what I was trying to get
Well, good for me.
last night in the statement, you did say recommended the wanton endangerment charges. So does that mean your client was frustrated that another recommendation was made, or that it didn't present the more of the evidence for the more serious charges?
And again, my client's concern is making sure that there's the appropriate information for the public as a whole to see what's going on, to make their own decisions on what happened. I think the important note to your question and hers is what we know now by their statement is there was a recommendation. We still don't know what charges, if any, were presented outside of that recommendation. And I think it's important for you all to know, as we said before, generally, in a typical case, the prosecuting body would present charges to the grand jurors, then put on testimony, then make an off-the-record recommendation. We don't know that that's what happened here because we're not getting those answers. We're not getting the level of accountability that the public deserves as far as what was actually presented. There are some very definitive statements from the original press conference that the Attorney General held where they stated certain decisions that were made, but they have yet to answer what was actually presented as far as the charges and the individuals they were directed to. And I think that is important for the public to know, and I think my client feels strongly the same. Yes, ma'am.
Is there a concern that if these filings are released, it puts that concerning is there a concern that if these filings are released, it puts that a precedent for future grand juries, where grand jurors won't be able to trust that the proceedings remain private as they are meant to?
Well, first what I'll say in response to that is I think it would be more dangerous to set a precedent to not disclose everything to the public that you're allowed to. Now, the more technical answer to your question is there's a very narrow and short rule that applies here. It's RCR 5.24 subsection 1, if you don't want to look it up on your own, that states the grand jury secrecy. And what it does state in the rule is that anybody who's in the room during the proceedings is sworn to secrecy, with only 2 exceptions in writing. One being that the court, at any time, at their discretion, can order the release of those proceedings. That's happened. The other exception within the rule is, again, the accused has a right to that information. And at that point, if you read the rule, it also states that the accused through counsel, or presumably pro se, can divulge certain information as a part of their own investigation or any subsequent hearings or trial on that action. So the message that gets out there right now that these are secret and they're never to be talked about is inaccurate. there are ways that it comes out. This was going to get to counsel for Detective Hankinson at some point, whether it's noon Wednesday, next week, or whenever. And what they do with it at that point, we don't know. But again, I think the dangerous precedent to set is more of a chilling effect of not letting the public in on what's happening and trying to distort that level of secrecy to the extent that you're, at least by appearance, not putting all of the truth out there. I think you're trying to ask one over there.
Did your client say anything about the AG putting charges against the other two officers involved in this case?
And again, I can't really tell you anything about our discussions. It's more an issue of trying to see how you fit into the conversation and getting the information out there that you're asking, because the public has a right to know.
New York Times quoted you say that your client was aggrieved that they couldn't consider charges against Madeline and Constance.
Was that in an actual quotation mark? Because that's not accurate.
But they
I
said
didn't
that-
say that, but what I can tell you is, again, I think my client is aggrieved to use that term, that what was presented is not being publicly disclosed. I think that's a more fair assessment of where
But
we
that
are.
wasn't a specific concern. Without saying what your client said, is that accurate?
The concern is truth and transparency. That's the best thing I can tell you right now. Truth and transparency.
Did your client say that there were charges presented against Mattingly and Costco?
And I'm sorry, I cannot tell you what my client told me in confidence.
How was your client?
Hold on, he's been trying, I'm sorry. Yes, sir.
Thank you. Was there a key piece of evidence that was not presented that should have been presented?
That's an excellent question. You should probably ask the Attorney General, and I'm not trying to be flippant, but that's part of what we're here for. These questions are not being answered right now. What we're getting from the Attorney General's office, twofold at this point, is that they presented everything. I would submit to you, based on their own statements, they didn't do that. They were asked pointedly by somebody who may be in the room why they made such a distinction between one witness regarding the knock and announce issue versus multiple other witnesses that said something different. These are the things that the public should probably know.
And is that what your client asked or told you? Did your client make any sort of like?
I can't tell you any discussions related to that I had with my client. What I'm saying is if you look at the two different statements from the Attorney General's office, they're telling you that they haven't told you everything, and they're indicating that they may not have actually presented what I would say is all the evidence. But we're not gonna know that until we hear the proceedings, until, if possible, the court agrees with our position and allows the grand jurors to discuss freely, what happened, what was presented, etc. And then obviously down the road at some point there may be a trial, whether it be on a civil action, the criminal action against Detective Hankinson, or any federal investigation that's ongoing. Will hopefully kind of crack open some more information as well.
So what's the next step here? Are you just gonna become public with like, so Cameron came to think that he got notice from the police based on the statement last night, in response to this motion that you filed or something, what I'm saying. You also said you didn't see a problem with the grand jury speaking. So what's the next? What's the next step here? Because you can't really talk about what your client is saying.
Well, hopefully the next step is that we get a ruling from the court that my client and fellow grand jurors can talk. But I think
You want the judge to, you're not gonna take.
let me take it this way, if that's okay. Let me address the press release itself. The press release from last night, I've read over it a few times because I figured you all were gonna want to talk about it. And it's important to our action. The first paragraph is almost exclusively about the court order that was issued yesterday by Judge Ann Bailey Smith at arraignment of Detective Hankinson. Read that paragraph however you want. Always things are subject to interpretation, but they're admitting, if you want to use that phrase, that they're going to comply with the court order. So what I think that tells everyone is they're not going to file a writ to take it to some higher court to address the issue of disclosure within discovery. It's an entirely different rule. So I think that portion of the statement last night is solely to say, we're not going to take that to another judge, we're going to comply with the order, and we will put it in the court file as discovery, which, other than the fact that it's going to be publicly in the court file, is the normal course of action for the disclosure of those recordings. The part that directly addressed our motion, if I recall word for word, and I won't, but I'll paraphrase as best I can, they have no concerns with grand jurors talking about the proceedings. Okay? No concerns with talking about the proceedings. No concerns doesn't necessarily mean when you hear something you don't like, you're not going to change your mind. But more importantly, talking about the proceedings in the same statement where you're saying I agree to the release of the proceedings as ordered by the court, potentially, and we believe, narrows it to whatever's recorded. And if you look at our motion, we very specifically stated that there should be an ability for the grand jurors to talk about the things that were not recorded, that are relevant to the accountability and the public trust that we're all seeking here. Because if no charges were presented against the other two, LMPD detective and sergeant, I believe, that's something that I believe the public really wants to know. If there were charges presented against those individuals, they want to know what they were. That may not be housed within those recordings, and we don't know that.
What would not be like, what would topic not be on, not on the recording, so what kind of discussions would the prosecutor have with the grand jury and may not be recorded?
So again, in typical course, it's been my experience that the only thing that is recorded is the testimony presented. There is not necessarily a discussion that's recorded between the prosecuting entity and the grand jurors about specific charges. What happens is, a lot of times what you hear is essentially them handing a document to the grand jury and saying, we're here on a case against so-and-so involving the following charges. And then they call an individual as a witness, put on some proof, and sadly in about 15 minutes people get indicted. But in this case, we know there are anomalies to the normal course. We know that it took roughly 2.5 days. That is, to use a term from a question earlier, it's unprecedented in Jefferson County, Kentucky at the state level. What we don't know is, when did they present charges? Did they do it in the recording? Did they present all the charges they alluded to? I know over here, I think earlier there was discussion of the statement of they walked them through the 6 different types of homicide, is I think close to what Attorney General Cameron said at the initial press conference. But now they say all they recommended was the wanton endangerment. That issue has not been cleared up. That issue has not been directly addressed. And those are exactly the concerns that our client has, that we believe other grand jurors probably have, and that the public has.
Based on your years of experience, Kevin, what was your first reaction? That's sorry for
That I have a lot more questions. I mean, that was my initial impression. I want to know what was presented, just like everybody else in the community. If you're going to definitively state this is my only recommendation, which I'll let you all go back and compare it to previous statements. I'm not sure that fully tracked the words from the first press conference. I think it leaves wide open what was presented, which has been directly asked and has not been answered.
How much of
Yes,
this
sir.
juror shared with you?
Sorry.
How much of this juror shared with you about what happened during those 2.5 days? Did they tell you everything that happened? Is there some stuff that they haven't told you yet? How much do you know?
We've had detailed discussions. I would probably never tell you that somebody told me everything that happened. In this instance, our client recounted as best they could their memory. Something for you all to keep in mind when we're talking about the secrecy and the rules. When you're under the impression or an order or an oath that you cannot disclose something, you gotta watch what you're doing. So what there doesn't exist, I would imagine, are written notes from grand jurors. Generally, those are taken from them after the proceedings because of these very rules that we're discussing. So there are most definitely things that I don't know, but a lot of what happened was discussed.
I have a couple of questions, I guess kind of logistically first. So Judge Ann Bailey Smith said, here's your order, we need these by noon tomorrow, to all proceed. So say, Daniel Cameron's office complied with that, a couple weeks down the road, if you had rules on your case, in favor, what more, I guess, with that, because you had already mentioned, the public, we will be able to access that by tomorrow, if Cameron's office doesn't comply.
Well, to some extent, that's gonna be left up to the judge. But I think I know what you're getting at, and I think it does potentially, if it goes the way we would like it to, I think it gives not only our client, but any other grand juror in this process the right to discuss that. We tried our best, and I'm sure if I went back and read it right now, I wouldn't be happy with everything in the motion, but we tried our best to do it in a way that would free up other grand jurors if they so chose. But whatever order comes from the court, I'm sure will be carefully considered and crafted, and it may only relate to our client, I don't know. But the hope would be, and I think again for the sense of transparency and just everyone who's interested knowing as much as they can, we sincerely hope that it would include everything that we put in our motion, everything that's not been recorded, questions that haven't been answered, and free these grand jurors up to have more candid conversations without the fear of any repercussion.
And my second question for you, when your client came to you on Friday, did he come to you, the conversation you initially had, did you feel it was more him coming to you from a personal standpoint of wanting to be able to talk about this and not get that backlash, or more of a community standpoint of he felt the community has a more of the right to know?
Honestly, I think it was both. Again, I mentioned we want grand jurors to take their service seriously because the result of an indictment is somebody's liberty interest. Arguably, the biggest interest any one individual has within our community regarding the laws of the land. But our client, at that time by Friday, had conflicting convictions. Wanting to do the right thing as a grand juror, but also wanting to do the right thing as a citizen at large, outside of that one proceeding or anything related to it. So the discussion initially was, how can you do that without opening yourself up to some form of repercussion from the authorities primarily, but obviously there are discussions of how does that play out, in the event you become known and you make these statements and you're subjected to what we're sitting here doing today.
Your client believes that allowing him or any grand juror to change whether it's grand jury, jury's decision is accountable.
I'm sorry, I lost you on part of that.
Sorry, does your client believe that enabling him or any member of the grand jury will change the narrative, what the information the public got on how the grand jury and the decision was made?
Well, the narrative in this case has been ever evolving, so absolutely. And I think, again, the point of the whole action is to get more into the narrative. And it's not really about changing the narrative, it's about opening it up to a more full truth for everybody to see. The court system's an interesting place because they talk about the truth, nothing but the truth, and we're going to get it all out there. In fact, I think Mr. Cameron even stated it, search for the truth. Sometimes you don't get all of that because of these certain rules unless somebody steps up and takes action. And again, our client felt a strong conviction to step up and take action to see if they could help get all that information out. So I think it probably does change some narratives, but that's going to be something that people consider on their own.
Just to follow up, is the grand jury think that grand jury was made a scapegoat?
I mean, again, I don't think I can talk about what we specifically discussed, but there were no derogatory terms used towards any officials or anything that was stated. And I'm not trying to pick at what you're asking me. But again, I think, and if you look at the motion we mentioned, when you run for a position or you're given a certain amount of authority, generally the public expects you to take a level of responsibility that's commensurate with that position. And I don't believe that happened here in the initial press conference. And I think we addressed that in our motion in hopes that not only is that responsibility being taken by the prosecuting authorities, but that it's being taken in a sense that it becomes a public issue for people to determine who's accountable for what in this action, who's accountable for their actions that happen on March 23rd, or who's not, and why. Those are all the questions that have been floating around downtown Louisville for months. And I think trying to figure out where you fit in that narrative, to use your term, is what this individual is trying to do so that everybody can get a better idea of what they feel about the process and what they feel about the responsibilities and the accountability of everyone involved.
Is your client the only grand juror that feels
I can only speak for our client, but I would imagine that there's a similar concern from at least some grand jurors, just based on what's been put in the public. But specifically, we did not discuss any other grand juries in our meetings.
If this ruling is in your favor or when the reporting come out, will that let the public know the racial makeup of this jury?
No, I don't believe so, no.
Do you know the racial makeup? Can you share that with us?
I have some information, but I can't share it with you. I would say that I don't believe that it was an atypical makeup.
So clarify, does your client want to speak out initially if they have a second ruling?
A couple things to that question. Our client has an interest in anonymity, not only because of the rules, but also because of the public scrutiny of the case. So at this time, I don't foresee coming off of that stance until a lot changes. If the ruling goes in our favor, as you put it, then we will address how the information gets put out there, whether it be done, in writing, through question and answer, whatever. We'll explore all those different options. We'll explore the issue of anonymity. But again, as asked over here, it's an ever-evolving narrative, and we have to have a court ruling before not only our client feels more comfortable releasing some information, but quite honestly, as a legal team, we're not going to advise our client to speak to anything that could possibly subject them to contempt of court or any other form of prosecution.
You mentioned a little bit ago that 2.5 days was unprecedented. Can you explain why it was that it took that long? I mean, I understand there were special things that happened in this particular grand jury, but I'm just spitballing here. Was there some big debate amongst the jurors? Like, did they have a problem with this?
Were put up, I will tell you, in light of that last statement, there are different rules in front of a grand jury as opposed to a jury trial. So witnesses don't have to have first-hand knowledge of whatever they're testifying to in front of the jury, which is very important for the public to know. So, in theory at least, 3 or 4 witnesses could have testified over 2.5 days to the statements of 20 different people. But these are all questions that are great and that should be answered. But I'm not at liberty to discuss that with you today, and I'm sorry about that, but I really hope the rest of that information does get out. Yes, sir.
Does the grand jury think that their opinions were misrepresented?
I mean, I can't speak to the grand jury as a whole, and again, I can tell you my client has an issue with the levels of accountability and disclosures that have happened to this point. And in our discussions, those concerns did not go away when we discussed the rule of secrecy for the grand jury, when we discussed the disclosure of discovery through the criminal process. So we felt compelled to act upon it, and we're going to sit back and hopefully get an order from the court that says we can help answer some of these questions.
Kevin?
Can I follow up just a second?
I'll leave that to you too.
If the Times attributed to you that your client felt their views were misrepresented and was aggrieved that they weren't allowed to vote on charges in the Iowa Constitution, are you disputing that, or are you just saying what it means? You didn't say that.
As you're relaying a quote to me, I can tell you I did not say anything like that. However somebody interprets something I say, I lose control over that. None of us really like that, quite frankly. But what I can tell you is, in the press conference after the indictment was reported, it was stated that certain things were presented and certain agreements were had between the grand jury and the team from the Attorney General's office. It is important, and our client feels it's important, that however they could have gotten there, whether they did or not, is something that the public gets to see. Yes, ma'am.
Kevin, this question doesn't have to do with the grand jury, or what you just said behind.
We'll see.
Did your client know that grand jurors had the ability to request or suggest other charges be discussed or presented before proceedings? And do they have that knowledge now after?
Well, hopefully my client feels like they have all the knowledge they could have on that, because we've had extensive meetings and discussions, but that's besides your point. That's a great question. And that's a question that hopefully can be answered directly by grand jurors in the near future, because you're right. The rules in Kentucky allow the grand jury as a body to investigate, to make decisions on charges, to ask questions of the prosecuting authority, and to ask about additional charges. We don't know if that happened here publicly. We don't know what all was discussed at all. We don't know what all is going to be in that recording, which, going back to questions over here, that's why we drafted the motion in the way we did, to try to get a ruling from the court to say, what exactly can we discuss? Are we limited to the only things that are recorded? Or can we talk about the things that weren't recorded? Because there may well have been questions asked. There have been questions asked about this case from day one, from everybody in the country, essentially, but by a whole lot of people. 12 people in a room that get to see more than anybody else has likely have a lot of questions as well. And that's something we'd like to see get out. Yes, sir.
You said the jury was not typical, or that it wasn't atypical to make it from the jury?
I don't have all the specifics. I said it wasn't atypical. What I can tell you is there's a standard process where summons are issued to prospective jurors in the Commonwealth of Kentucky. It's my understanding that was complied with. This was a regular panel. This was not a special grand jury. I am of the opinion the Attorney General, if they so chose, could have impaneled a special grand jury, but they didn't do so. So it's my understanding it's not an atypical makeup when you're looking at demographics. It would be the normal course, which it probably appears underrepresented by minorities, but that's something that perhaps becomes a part of the bigger discussion, because that's not atypical in Kentucky. And there are different reasons why that it's not a part of what we filed, but I think that's important to note if and when you find out the actual demographics, because the whole point of getting all this out there is to see what the next steps are and the next questions. And those are the concerns that our client had too. And if that involves how do we impanel grand juries, if it involves how do we seek and obtain and execute search warrants and things of that nature, these are the questions we're hoping get answered.
And how much of this case did your client know before they served on this grand jury?
I don't believe that my client knew much about the case at all prior to serving on the grand jury.
I have one last question.
I have to ask them at some point, or it's going to have to come out through the evidence in some case as to who actually made that decision. But it sure sounds in that one like they did, the Attorney General's office.
So I got one last question for you. So
Yes,
now
sir.
the Attorney General says that they're going to release the grand jury report.
Because they have to.
Right. Does that satisfy what you guys put
No.
out for?
No, and I want to make that very clear, because, again, the proceedings don't contain everything that happened with the grand jury. It doesn't cover anything that's not on the recording, obviously, right? So whatever discussion, if it's about charges or why we didn't make certain charges, how do certain defenses apply, what additional facts are there, if it's not recorded and the grand jurors are not given the liberty to speak about that, then nobody's ever really going to know about that. Or maybe somebody takes the chance and discloses something and subjects themselves to being put in jail for 6 months, because that's the penalty for contempt of court. Our motion is still active, and we're not backing off, because we need to know, are we going to get it all out there, or are we only going to go with what's on the recording?
So you said your client didn't really know much about this case before you served the grand jury. This is pretty well documented, the history of this case, especially in Louisville. Your client's from Louisville. Like, how did your client not know much about this case? And why he didn't know much before, now afterwards, he filed a suit that he wasn't successful now. It wasn't, that involvement before.
I think I follow your question. And I'll say this. I'm not sure anybody within the community who does not work in law enforcement or in the legal community, in the court system, etc., really knew a lot about this case before it went to the grand jury. There are lots of questions about facts and witnesses that are still out there. Again, there were questions asked in the press conference about statement of one witness versus the statement of multiple other witnesses to the contrary. So I don't know what level of time my client spends watching the news, or how they, interact on social media, that's irrelevant to our action. But to answer your question as to why do you then seek some sort of declaration of your rights, it's because you did participate for 2.5 days in these proceedings. My client now knows a lot more than most people, certainly more than the general public, and then, obviously has seen how it's been handled from that point. And again, within short order, felt compelled to seek out some information as to their rights because they felt compelled to help get all of the information out to the public. Very good.
All right.
Thank you all very much. Appreciate it.
Okay, my royal family. Well, what comes to mind, my royal family, what I was thinking, because I'm listening to this in real time with the royal family. There's a lot of questions come up. I know somebody has spoke about something about along a line of double jeopardy. Well, this was to get an indictment. This was not necessarily putting on a trial. So the question that I would ask, what is and what isn't binding in a possible indictment? And so we all gonna find out tomorrow based on whatever that was presented or not presented, because based on the way this lawyer is talking, there was a lot of deception. And so trust and believe there are going to be legal experts listening to as well and even deeper, because they're going to break it down. And what they're going to see is, did the DA violate? And if he violated, then it's some issues that he have to deal with. And trust and believe, he ain't getting no peace. He ain't getting no rest. He ain't getting no sleep. Because at the end of the day, he know what his intentions was. So he manipulated things in such a fashion that he already knew what the outcome was going to be. And most DAs do. And it really, what this really is based on how they feel and who they are loyal to. Now, let's go over here for a second and look at our queen. She was murdered. Somebody died in this process. And that's extremely disturbing to many of us. And then you take this definition of a true nigga and he tried to muster up some tears like he cared, based on how he manipulated this case. He had no regard at all for our queen's life. Now, anybody that's new to the true royal family or true royal, I speak about looking at things with your spiritual eyes, being and ears, just embody all of this. And what comes to mind is the statement that Breonna Taylor's mother made, that our queen here often would like to apply pressure when somebody is doing you wrong in order to get some results. So pressure was applied. And how did that pressure come? Directly from Breonna Taylor. Her spirit will not rest until there is total justice. And it makes me also think about the pig that was shot with his night terrors. Nobody getting no peace in this. Now, ultimately, at the end of the day, it is the divine hand. This is one of his children. And you're looking at all these different dynamics. And, his duty and responsibility is business as usual. them days is over with. And what I've been trying to point out also through many, not just on this case, but through many of videos about being empathic, also about we wasn't totally stripped of our powers and what we are capable of doing. And it doesn't take the collective royal family to do these things. So when I'm saying speaking very clear into the universe, really we're, these are our prayers and we're speaking directly to our Father. And I'm overemphasizing speaking into the now opposed to the presence. And that's something that we have to work ourselves up out of. Me too is included, but being very crystal clear. Whatever we're praying to our Father, so these things can be executed. And people laugh at you when you talk the way that I do. There's many of us out here. Oh yes. I mean, it's amazing to me the things that I hear behind the scenes from the royal family. Because for a while I felt like I was by myself, and I jokingly say to my husband, and he instantly knew what I meant when I said I found him. And he knew what I meant, because when you are empathic and highly favored, a lot of stuff come in and you need somebody to talk to. And then you're dealing also with the dynamics of being affected by the system, and then you don't want nobody to deem you crazy. That's why I even say, because I'm going to always remain humble, I don't always get it right, because I'm affected too. And sometimes even when I'm speaking about stuff based on how I feel, I speak with passion and conviction, so certain emotions will come out, and I'm not going to speak favorably of the person. I'm not trying to execute perfection over here. What I'm executing is my true nature, and I'm not going to speak in a fashion where it gives the enemy what the enemy wants. If I feel like cussing or saying whatever, I'm going to say, I'm even known for putting some titles that don't even really represent what actually happened. But that's how the enemy get down. Like I said, at the end of the day over here on the True Royal Family and True Royal, I'm going to always slant it in our favor. I don't care what the situation look like. This is what the enemy do. See, game recognize game at the end of the day, my Royal Family. So, Wednesday is the big day. And we need to keep doing what we're doing with the enemy and their supporters. You get no peace, no sleep, no rest, or anything. And I'm going to say this again to the people that I'm controlling right now and listening. Again, even if you think about doing anything to us, and it does not matter that you don't execute it, just thinking like that, in that fashion, you will have eternal damnation in hell. Just thinking like that. So you really need to stay up out of our affairs and stop hating on us. You cannot stop prophecy. You cannot stop the momentum that is going on in the universe. And see, what these demons are essentially saying, they want what's going on, what we are experiencing and what we are feeling, my royal family. They want this to go on to eternity. And they'll wear a thing out where eventually it gives. Enough is enough. And trying to dress it up where you put the face of like you think you hoodwinking and fooling us. You ain't fooling our Father. And you ain't fooling his children either. See, you do the same repetitive shit so long, we know what you gonna do before you do it. So, as I close out, back to our queen. You will get your rest eventually. And that's in our Father's time, my queen. I and others are doing all we can to be obedient and to the best of our ability to put out the truth. You were done absolutely wrong. And it has penetrated and touched many of us. That you just minding your business, chilling with your man. And the next thing you know, you in a deep sleep. And could you, my royal family, imagine the state of mind our queen was in with all the noise that you hear and the battle of gunfire? Could you imagine? Could you imagine if she even took those bullets and lived with it? I don't think her psyche could handle that, because that would deeply scar you. You ain't did nothing wrong. And then this is what you have to experience. So I'll leave it there, my royal family. But the word I'm using at the end of the day, busted. Your ass is totally busted. So, my royal family, render your voice with your beautiful divine words. And it's always, my royal family, I thank you for your love. I thank you for your support. And with that said, Ashe.